Good morning and welcome to the inaugural session of the National Conference 2024, a student-led initiative organized by the Students' Union in collaboration with the Law Journal Club and the Bhagath Singh Study Circle of Government Law College, Ernakulam. As we know, 2024 is the 150th year of inception of the Government Law College, and such is the legacy of this illustrious institution that most of the dignitaries present here today are alumni of our institution. What a rare privilege it is for any educational institution. Our chief guest today is none other than Justice K.M. Joseph, a distinguished alumnus of our institution and a former judge of the Supreme Court of India. Justice K.M. Joseph's judicial career is marked by his unrelenting commitment to upholding constitutional principles and judicial independence. Renowned for his integrity and legal acumen, he has been a significant part of decisions that safeguarded fundamental rights and strengthened rule of law in India. Our next guest is Mr. P. Rajeev, Minister for Industries, Law and Choir in the Government of Kerala. He too is an alumnus of the Government Law College. Before taking up full-time political and organizational responsibilities, he was a practicing lawyer at the High Court of Kerala. Known for his articulate speeches and strong stands on policy matters, P. Rajeev has been a vocal advocate for social justice, economic equality, and progressive reforms. We also have with us Advocate Manoj Kumar, alumnus of the Government Law College, Ernakulam, and attorney of the state of Kerala. He has represented our state in many significant and decisive cases. He has also been our biggest support and mentor to us throughout the organization of this conference. Now, as we begin our inaugural session, I call upon Isa Fahan, our chairperson, to officially welcome everyone to this event.
Good morning. വേദിയിലിരിക്കുന്ന വിശിഷ്ട വ്യക്തികളെ, പ്രിയ വിദ്യാർത്ഥി സുഹൃത്തുക്കളെ, അധ്യാപകരെ, നമ്മൾ ഉദ്ദേശിച്ച സമയത്തേക്കാൾ കുറച്ച് വൈകി. കാരണം വേറൊന്നും കൊണ്ടല്ല, നമ്മൾ മഴ കാരണം വിദ്യാർത്ഥികൾ വൈകുമെന്നൊരു നിഗമനമുണ്ടായിരുന്നു. അതുകൊണ്ടൊന്ന് കുറച്ച് പോസ്റ്റ്പോൺ ചെയ്തു. പക്ഷേങ്കിൽ നമ്മൾ ഉദ്ദേശിച്ച എല്ലാ ഗസ്റ്റുകളും വിദ്യാർത്ഥികൾ എത്തുന്നതിനേക്കാൾ മുന്നേ നേരത്തെ എത്തിയിട്ടുണ്ട്. അപ്പോൾ ആദ്യം തന്നെ ഗസ്റ്റിലോടൊന്ന് ക്ഷമാപണം നടത്തുവാണ് കോളേജ് യൂണിയൻ വിദ്യാർത്ഥികൾക്ക് വേണ്ടിയിട്ട്. നമ്മുടെ കോളേജ് 150ാമത്തെ വർഷത്തേക്ക് കടക്കുകയാണ്. 2024 150 വർഷം എന്ന പാരമ്പര്യമുള്ള ഏതാനും വളരെ ചുരുക്കം കോളേജുകൾ മാത്രമേ നമ്മുടെ രാജ്യത്തുള്ളൂ. അപ്പം അത്തരത്തിലൊരു വലിയൊരു ക്യാമ്പസിൽ പഠിക്കുക എന്നുള്ളത് എല്ലാവരെയും ഭാഗ്യം തന്നെയാണ്. നമ്മുടെ ക്യാമ്പസിലെ അലുമിനിയസ് ആയിട്ടുള്ള എല്ലാവരും തന്നെയാണ് ഇന്ന് ഈ ഡാസിലിരിക്കുന്നത്. അത് ഞങ്ങളുടെ മറ്റൊരു വലിയൊരു ഭാഗ്യം തന്നെയാണ്. ഈ 150ാമത്തെ വർഷത്തേക്ക് കടക്കുന്നതിൻ്റെ ഭാഗമായിട്ടാണ് ഈ 2023-24 വർഷത്തെ കോളേജ് യൂണിയൻ ഒരു നാഷണൽ കോൺഫറൻസ് സംഘടിപ്പിക്കുക എന്നൊരു ഉദ്ദേശമായി മുന്നോട്ട് വന്നത്. ഇത് ഈയൊരു 3 ദിവസത്തിന് പിറകിൽ കഴിഞ്ഞ 3 മാസത്തെ നമ്മുടെ ക്യാമ്പസിലേക്ക് 100-ലധികം വിദ്യാർത്ഥികളുടെ, അധ്യാപകരുടെ, നമ്മുടെ മറ്റ് പുറത്തുനിന്നുള്ള പലരെയും ഹാർഡ് വർക്ക് ഉണ്ട്. അതിൻ്റെ ഒരു ഫലമായിട്ടാണ് ഇത്തരത്തിലൊരു വേദി, ഈ 3 ദിവസത്തെ വേദി കഴിഞ്ഞ 3 മാസത്തെ അധ്വാനത്തിൻ്റെ ഭാഗമായിട്ടാണ് ഇവിടെ നമുക്ക് സാക്ഷാത്കരിക്കാൻ കഴിഞ്ഞത്. അതിനുവേണ്ടി കൂട്ടുന്ന എല്ലാവരോടും അതിന് നന്ദി പറയുകയാണ്. എല്ലാവരും കാത്തു നിൽക്കുന്നത് ഇവിടെ എത്തിയിരിക്കുന്ന അവിഷ്ട വ്യക്തികളെ, അവരുടെ വാക്കുകൾ കേൾക്കാൻ വേണ്ടിയിട്ടാണ്. അപ്പോൾ ഞാൻ കൂടുതൽ സംസാരിക്കുന്നില്ല. ഞാൻ ഔദ്യോഗികമായിട്ടുള്ള കർത്തവ്യത്തിലേക്ക് കടക്കുകയാണ്. ഈയൊരു നമ്മുടെ നാഷണൽ കോൺഫറൻസിൻ്റെ ഉദ്ഘാടന ചടങ്ങിന് പ്രസിഡൻഷ്യൽ അഡ്രസ്സ് കൊടുക്കുന്നത് നമ്മുടെ കോളേജിൻ്റെ പ്രിൻസിപ്പളായിട്ടുള്ള ഡോക്ടർ ബിന്ദു നമ്പ്യാരാണ്. ഏറെ സ്നേഹത്തോടെ മാമിനെ ഈ വേദിയിലേക്ക് സ്വാഗതം ചെയ്യുന്നു. ഈ കോൺഫറൻസ് ഔദ്യോഗികമായിട്ട് ഇവിടെ ഉദ്ഘാടനം ചെയ്യാൻ എത്തിയിരിക്കുന്നത് നമ്മുടെ അലുമിനി കൂടിയായിട്ടുള്ള കേരള സംസ്ഥാനത്തിൻ്റെ വ്യാവസായിക നിയമ കയർ വകുപ്പിൻ്റെ മന്ത്രിയായിട്ടുള്ള ബഹുമാനപ്പെട്ട ശ്രീ പി. രാജീവ് സാറാണ്. അദ്ദേഹത്തെ ഏറെ സ്നേഹത്തോടെ സ്വാഗതം ചെയ്യുന്നു. ഇന്നത്തെ നമ്മുടെ ചീഫ് ഗസ്റ്റായിട്ട് നമ്മുടെ ക്ഷണം സ്വീകരിച്ച് ഇവിടെ എത്തിയിരിക്കുന്നത് നമ്മുടെ അലുമിനി കൂടിയായിട്ടുള്ള മുൻ സുപ്രീം കോടതി ജഡ്ജി കൂടിയായിട്ടുള്ള ജസ്റ്റിസ് K.M. ജോസഫ് സാറാണ്. ഏറെ സ്നേഹത്തോടെ സാറിനെ ഈ വേദിയിലേക്ക് സ്വാഗതം ചെയ്യുന്നു. ഈയൊരു ഉദ്ഘാടന ചടങ്ങിന് കീനോട്ട് അഡ്രസ്സായിട്ട് ഇവിടെ എത്തിച്ചേർന്നിരിക്കുന്നത് നമ്മുടെ മറ്റു അലുമിനി കൂടിയായിട്ടുള്ള നമ്മുടെ കേരള സംസ്ഥാനത്തിൻ്റെ സ്റ്റേറ്റ് അറ്റോർണി കൂടിയായിട്ടുള്ള ബഹുമാനപ്പെട്ട അഡ്വക്കേറ്റ് മനോജ് കുമാർ സാറാണ്. സാറിനെ ഏറെ സ്നേഹത്തോടെ സ്വാഗതം ചെയ്യുന്നു. ഈ ഉദ്ഘാടന ചടങ്ങിന് ആശംസ അർപ്പിച്ച് സംസാരിക്കാൻ വേണ്ടിയിട്ട് ഇവിടെ എത്തിയിരിക്കുന്നത് നമ്മുടെ PTIയുടെ വൈസ് പ്രസിഡൻ്റായിട്ടുള്ള ശ്രീ അഡ്വക്കേറ്റ് PT ഗിരിജൻ സാറാണ്. ഏറെ സ്നേഹത്തോടെ സാറ് സ്വാഗതം ചെയ്യുന്നു. അതുപോലെ തന്നെ ആശംസ അർപ്പിച്ച് സംസാരിക്കുന്ന നമ്മുടെ കോളേജ് യൂണിയൻ്റെ സ്റ്റാഫ് അഡ്വൈസർ കൂടിയായിട്ടുള്ള മിനിപ്പോൾ മിസ്സിനെ സ്വാഗതം ചെയ്യുന്നു. ആശംസ അർപ്പിച്ച് സംസാരിക്കുന്ന നമ്മുടെ അധ്യാപിക കൂടിയായിട്ടുള്ള ശ്രീ പ്രേംസി മാമിനെ ഏറെ സ്നേഹത്തോടെ സ്വാഗതം ചെയ്യുന്നു. നന്ദി അർപ്പിച്ച് സംസാരിക്കുന്ന കോളേജ് യൂണിയൻ്റെ വൈസ് ചെയർപേഴ്സൺ കൂടിയായിട്ടുള്ള സഞ്ജനയെ സ്വാഗതം ചെയ്യുന്നു. എല്ലാറ്റിലും ഉപരി ഈയൊരു ഉദ്ഘാടന ചടങ്ങിന്, ഈയൊരു കോൺഫറൻസിന്, 3 ദിവസത്തെ കോൺഫറൻസിന് ഇവിടെ എത്തിയിരിക്കുന്ന എല്ലാ വിദ്യാർത്ഥികളെയും അധ്യാപകരെയും നമ്മുടെ വളണ്ടിയർമാരെയും കോളേജിലെ അധ്യാപകരെയും എല്ലാവരെയും ഒറ്റവാക്കിൽ സ്വാഗതം ചെയ്തുകൊണ്ട് നിർത്തുന്നു. നന്ദി, നമസ്കാരം.
Thank you, Farhan. Next, our principal, Dr. Bindu M. Nambiar, will give the presidential address.
Good morning, everyone. Respected dignitaries on and off the dais, friends, colleagues, and my dear students. It is a proud moment for me to stand before you as we are celebrating our 150th year. I am an alumni of this institution. I came here at the age of 17 in 1986, and till now I am standing here as part and parcel of this institution. As we are celebrating this, our students have made this wonderful initiative of organizing this national seminar. Our college union and all the members who have associated with this have organized this wonderfully. Each and every aspect, they have been behind this for 3 months, past 3 months. And yesterday we have started this, and every aspect has been dealt wonderfully. Congratulations to each and every one of you. We all know that when our constitution has been framed by the founders of our constitution, headed by Dr. B.R. Ambedkar, we have been in a very difficult situation as the partition of India has been happened, independence have been gained, and there has been very great challenge before them to create a document which will encompass this diverse society of ours. And they have made a wonderful document, which is a living, breathing document. And as we all know that society is being changing rapidly, and in order to accommodate these changes which has been growing in the society, our constitution also have been going along with that. We all know that the framers itself has made provisions for accommodating these changes in accommodating these amendments of constitution. And there have been many amendments. We all know that even after all these years, our constitution is standing in a very bright light, guiding us in going forward. Even then, the founders of our constitution, they have envisaged many great things. Even after all these years, some of them have not yet been accomplished by us. There are many people who have not been made equal to everyone. There are persons, there are children who have not getting education. There are poverty in our society, and there are many social economic factors which have been affecting. Even then, our country is going forward. It is our duty, the duty of every citizen, to uphold, to safeguard our constitution. We should strive to achieve the constitutional principles which have been given to us. Especially, it is the duty of the law students. You have a great duty to uphold the principles of our constitution, to take our country to great heights. I hope all of you will strive to attain that hope, that aim. Thank you. Jai Hind.
Thank you, ma'am, for your wonderful words. Now, the most significant event of the day is here, the inauguration of the National Conference 2024. I request our Minister, P. Rajeev, to inaugurate the conference and speak a few words.
President of the meeting, Dr. Bindu M. Nambiar, Honorable Justice K.M. Joseph, former Supreme Court Judge, my friend Advocate Manoj Kumar, Advocate Girijan, and other dignitaries present here on and off the dais, and participants of the seminar, faculty and students. As an alumni, it is also a privilege for me to be here with you in the 150th year of this prestigious institution. Some days back, some of the former students came to me and they have made some proposal for transforming this institution as an institution of national importance. And earlier, Professor Girisankar is here. During his period, we had discussed in that aspect also. I assure one thing, we can work together to transforming this institution as an institution of national importance. But national importance not in accordance with the Constitution provision 66, that is totally under the jurisdiction of the Union government. Then I would like to congratulate the Students' Union for conducting this seminar on a very relevant topic in contemporary India. That is on the Constitution in a changing India. Honorable Justice K.M. Joseph is here. He is not only as a former judge of Supreme Court, as an expert on Indian Constitution. I think he will make some important remarks what is happening to the implementation of the articles of Indian Constitution and also interpretation of the apex court of our country. As a student of Indian Constitution, recently I wrote a small book, and in that book I gave a quote of Dr. Ambedkar that I will read. Quote, "However good a constitution may be, if those who are implementing it are not good, it will prove to be bad. However bad a constitution may be, if those implementing it are good, it will improve to be good." Right, this is the quote by Dr. B.R. Ambedkar. Our constitution is the largest constitution of the world. More than the time of framing, more than 1,17,663 words in that constitution. And now, Dr. Bindu M. Nambiar mentioned that several amendments were made for our constitution, more than, I think, 106 amendments after adopting this constitution. American Constitution was adopted in 1787. Till today, only 26 or 27 amendments were ratified by the states. More than 30 were passed by the parliament. Only 27 amendments were ratified by the states. But after 1950, our parliament have made amendment 106 amendments. All of us well aware that the beginning of the preamble, that is we the people, actually it was adopted by a voting. Mr. Kamath made an amendment, that is the preamble, beginning of the preamble as in the name of God. Then there was a good argument in the Constituent Assembly. And some of the members insisted that Mr. Kamath, you should not put God for voting. But he insisted for a voting, and 68-41. 41 in favor of in the name of God, 61 against. And Constitutional Assembly adopted the preamble of the Constitution. We the people, that is as same as the beginning of the Constitution of United States of America. We the people of United States of America. What is the difference in between that we the people and this we the people? The dictionary it is same, we the people. But while adopting the Constitution of America in 1787, that we the people was not consisted of the majority of the American people. The black not included in that we. Most of the audience are girls. Women are not included in that we. Poor who cannot afford to pay the poll tax, that were not included in the meaning is same in the dictionary, we the people. But in 1787, that we not includes poor, black, and women also. But it is expanding by the amendments and the interpretation of the Supreme Court of America. I think in 1867 or 68, 14th and 15th Amendment of the American Constitution, that is for giving voting right to the blacks. But that is only in the paper. After passing the Voting Rights Act, the blacks got the opportunity to cast their vote in America. That is in 1960s, the blacks were included in the we, the people of America. Then what about the woman? Only 1920, August 18. From 1787 to 1920, August 18, the women of America were not included in the we, the people of United States of America. And there was an interesting clause, grandfather clause. A grandson can vote only if the grandfather has the right to vote in his period. Grandfather clause was there. Poll tax was there. Then only after 1920, we the people became the same meaning in the dictionary, we the people of United States of America. But Indian Constitution, while adopting 1950, the we includes all people, irrespective of caste, religion, irrespective of any creed, irrespective of their economic status. All people of the country is included. Only for political equality. Ambedkar, in his famous speech, after presenting the draft, the last speech in November 25th, one man, one vote, one value. In politics, we are going to equality. But in economic structure, due to the existing economic structure, there is a difference in economic and socio-economic structure. He had mentioned in his last speech in the Constituent Assembly. But in India, I have mentioned in America, the we is expanding, including all. But India, it is confined. After the CAA. Article 14 is very interesting article of the Constitution. Equality before law to all person, not to the citizen. All person in the territory of the country. Equality before law and equal protection of law. To all people, irrespective of Muslim, Christian. But the CAA confines Hindu, Sikh, Christian, Jaina, Buddha, Parsi, 6, not Muslims. It is confined to the people from Pakistan, Afghanistan, Bangladesh. The V, actually Article 15 to 11, which is dealing with the Citizenship Act, citizenship by birth. There was an attempt to confine this V at the time of Rajeev Gandhi in a CAA. Then one of the parents should be an Indian citizen. Article 50 is very wide, including all by birth. That is adopted by most of the developed countries, citizenship by birth. Whether the parent, one parent may be Russian, one parent may be American. There was an interesting debate in the CAD. If a woman gave birth to a child in Mumbai airport, the parents are foreigners, then we can give citizenship to this kid. Then clearly declared by the Constituent Assembly, we should give citizenship irrespective of parents belongs to foreign countries. But that during the period of Rajiv Gandhi, there was an amendment. One of the parents should be Indian citizen. At the time of Vajpayee, Parliament made another amendment. None of the parents should be a illegal migrant, but not on the basis of religion. This was the first attempt to confine the V on the basis of religion. I would not like to take more time. Because thanks to the Kesavananda Bharati case, that is, make some limitation for amending the constitution. Parliament has no power to amend the constitution by changing the basic structure. But without changing the constitution, we can change the constitution by practice. Article 93 is here in Indian, still it is here. What is Article 93? The House of People shall choose 2 of its members as Speaker and Deputy Speaker, as soon as may be, like that. See, some sentences are very interesting, as soon as may be, as early as possible. Wide interpretations are there. Now, last phase of this Lok Sabha election is going to be held on this first day after tomorrow. The last Lok Sabha could not find time, as maybe, to choose one of its members as Deputy Speaker. Big majority for the ruling party, but the last Lok Sabha did not get a chance to choose a Deputy Speaker from their member. A case is pending before the Supreme Court. There is also, as early as possible, they will examine the merit and demerits of the case. Then recently in Kerala, university's case, no university is vice chancellor now, a very interesting interpretation of the apex court. That is regulation 254 article. Article 254 is very clear. Inconsistent with law made by the parliament and law made by the state legislature. The frame is very clear. Law made by the parliament. What is interpretation of the apex court? That is, regulation is an integral part of the act. If an inconsistent with the regulation and the state law, then regulation shall prevail. How? That is the apex court interpretation. What is law made by parliament? Law made by parliament is clearly defined by the constitution itself. 3 readings, first reading, second reading, third reading. Introduction, consideration and passing. It's a democratic process defined by the constitution. And parliament makes some more expansion by making rules. If the house decides, it's sent to a subject committee within the members. But if it is a matter is public interest, then the parliament, as speaker, has power to send it to select committee. Select committee has a power to hear the opinion of the whole people. That is the extension of the parliament. That is law made by Parliament and law made by the Legislative Assembly. Constitution provisions are there. That is why our Constitution is a big, largest Constitution. Some of the administrative exercise, legislative exercise is clearly explained in the Constitution itself. And Ambedkar gave a very clear explanation for that also, because we are immature democracy and something should be defined in the Constitution itself. What is the rule? Rule laid on the table of the House. Laid on the table of the House is not the same as the law made by the Parliament. Entirely different. Law made by the Parliament is a constitutional activity of the legislature. Then UGC regulation is prevail on a state law. What is UGC regulation? You go to the state list, 30, entry 30, very clear. Incorporation or regulation, cooperatives and universities, still it is in the state list. After the Constitution Amendment, which put education into concurrent list, corporation and incorporation of the universities is still within the state list. You please look into entry 44 of the union list. It is clear. Incorporation and regulation so and so without the universities. Very clear. Amendment was there, but put only education into the concurrent list. I got an opportunity in the Parliament to make an objection to the introduction of a bill for incorporation of University Bundelkhand in Uttarakhand, State University. Sharad Pawar moved the bill, Kapil Sibal was there. And Kapil Sibal said, how many universities were incorporated by us? Then I said, I was a law student, you cannot overrule constitution provisions by precedents. That was the decision of the upper house. Then Sharad Pawar moved an amendment converting that institution as an institution of national importance. If an institution is a national importance of institution, then legislative competency with the Parliament. How a statutory subordinate legislation prevail on a law made by the Parliament? Every day in the Assembly and Parliament, several SLR are laid on the table. Nobody cares about it. A committee on subordinate legislation is. If you get time to look into the debates on Rajya Sabha 2012, May 12, I got the privilege to move the first annulment motion in the history of Indian Parliament. From the beginning to 2012, May 12, the Parliament never witnessing any motion to annul a rule. That was declared by Arun Jaitley, the then LOB, in the House itself. Very rarest occasion. Then this is a wrong interpretation of the Apex Court. Very clearly expressed in the Article 30, Incorporation Regulation. Then UGC on Entry 25. What is Entry 25? If you read Constitution, you should read with CAD to know the legislative intent. What was the legislative intent of Entry 25? There was a debate at that time also. These standards, determining standards, may use to curtail the powers of the state legislature. It was there in the CAD. They will try to curtail the powers of the state legislature. Then Ambedkar said, what is the standard of education? If Madras University gave a degree to a students who get a mark in 35%, if Mumbai University gave a degree to a student who got a mark of 50%, difference is there. What is a graduate? Then there should be a qualifying marks. That is the original intention of Entry 25 in the Constitution. It is there in the CAD. But this interpretation changing. 254, very clear law made by the Parliament and law made by the state legislature. Then these type of interpretation also limiting the articles in the Constitution. All these aspects should be discussed. I would not go to the other details because of the constraints of the time. I have to attend some meetings due to the heavy rains in the district. I think Justice K.M. Joseph he will make some remarks with new developments with regard to the Indian Constitution. By these words, I declare this National Conference on the Constitution in a Changing India is being inaugurated. Thank you.
Thank you, sir, for your sharp words. As the minister reminded us, unlike the American Constitution, the Indian Constitution has been an inclusive one from the moment of its inception. Let us always strive to resist any attempts to dilute its inclusive nature. We'd like to present our minister with a memento to mark the occasion.
സാറ് സംസാരിക്കുന്നതിന് മുമ്പ് ഒരു കാര്യം, വ്യവസായ മന്ത്രി എന്നതിൽ സന്തോഷകരമായ കാര്യം, ഞങ്ങൾക്കെല്ലാം നൽകിയിട്ടുള്ള ഈ ചെടി ഇവിടുത്തെ ഒരു കുട്ടി തന്നെയാണ് അത് കമേഴ്ഷ്യലായിട്ട് സംരംഭകയായിട്ട് മാറിയിട്ടുണ്ട്. കൺഗ്രാജുലേഷൻ.
Justice K.M. Joseph, sir, will return in 5 minutes. There'll be a slight delay in the program. Please be patient with us.
Hello. A very good morning to all of you. All the distinguished persons sitting on the dais and off the dais. I find the principal of this Dominic College in Kajanapalli, familiar faces, my dear students and members of the faculty. And it's homecoming for me. I did law from this college way back in 1978, passed out in 1981. It gives me, in fact, inexpressible, in words, pleasure and deep honor to be here in your midst. It's a great tribute that, in fact, the students have made to this institution, which is entering into its 150th year. By organizing a national symposium, it's a befitting honor, a tribute by the students. And a big congratulations to each one of you. This institution was established in the year 1874, which makes it the 150th year today, this year. It was established by the Maharaja of Cochin. A big, round of salutations to the vision of the Raja of Cochin for establishing this temple of learning. The foresight they had is admirable. As you all know, it was in the year 1858 that the reins of government passed to the British Crown under the Transfer Power Act of 1858, immediately after the first rebellion of 1857. We had many nationalist movements gathering momentum. In the second half of the 19th century, we had the Congress Party being established in 1885. The British also kicked off reforms with the 1861 Councils Act, followed up by the 1892 version of, again, the Councils Act, and the finally brushed up last version of the Indian Councils Act of 1909. The Government of India Act of 1919 marked the first experiment with devolution of powers in India by the British. We had the legislative lists between what was called the governor's provinces. And you must realize all this was happening in British India. And Travancore and Cochin were princely states like many of the nearly 700 princely states we had in India. In fact, when V.P. Menon, one of the tall, eminent federalists, if I may call him so, because he was, along with Sardar Patel, responsible for India today as we know it today. In fact, he writes in his book, The Integration of Indian States. I would commend you to read it. That it was perhaps after the time of Chandragupta Maurya that India came to be consolidated as a geographical entity in the form of what we can describe perhaps as 2/3 of the old British India, which is called as British India, because as you know, slowly the East India Company came consolidated by treaties, war, and so on and so forth. So he says in his book that it made the task of the nationalist leaders easy because they had a common enemy to fight against, the idea of India. Because imagine if the British had not come. I am not saying that I am an Anglophile. I'm not praising them for a moment, but I am saying that perhaps by unwittingly, it was a blessing in disguise for the freedom fighters. They had one chunk of territory and the rulers to fight against. And finally, when it was consolidated and then the British took over, they had just the British to fight and they had the territory. It was through the efforts after the 1935 Government of India Act was passed, on which primarily our constitution was modeled on, that the Government of India Act of 1935, in fact, also improved upon the 1919 version. Very elaborate provisions relating to the form of government and so on and so forth you find. The Indian Independence Act passed in the year 1947, and the partition, horrific partition, which led to the loss of millions of lives on both sides, of two communities in particular, was a setting in which the Constituent Assembly sat and deliberated. And they took 2 years, 11 months, and 18 days. On the 26th of November 1949, they adopted the Constitution, and it was to come into effect on the 26th of January 1950. And that is how we celebrate the Republic Day, on the 26th of January 1950. The Honorable Minister spoke about we the people. Now, we the people, does it convey the idea that it is actually we the people who directly drafted it? No. It is the nearly 300 members of the Constituent Assembly who were responsible for doing that. Were the members of the Constituent Assembly directly elected by the people of India? No. They were elected by the members of the provincial assemblies, which had by that time come into force in British India under the Government of India Act 1935. And as far as the princely states were concerned, like Travancore and Cochin, they had their own assemblies. So we had nearly 6 members from what we call today Kerala. So at the end of very fruitful deliberations by very eminent men drawn from various walks of life, public life, we have the Constitution. And the Constitution, when it was drafted, when it came into force on the 26th of January 1950, it consisted of 1,45,000 words. It was the second longest constitution, which it remains even today, after the state of Alabama in the United States. Because as you know, in the United States, there you have the federal constitution and all the states have their own constitution. So the second longest constitution after. The 108 amendments over a span of 75 years since 1950 have led to the insertion of more articles. And today we have, in place of 395 articles, which we had to begin with, we have nearly 450 articles. In place of 8 schedules to the original constitution, we have 12 schedules. In stark contrast is the US Constitution, which, as the minister said, 1787, and the Bill of Rights in 1791. It has just 7 articles. It has been amended, and we have already 27 valid amendments over a period of 2 centuries and little over 3 decades. Now, we are all imperfect. And therefore, the institutions we make will also be imperfect. So the fact that it has been amended 108 times is not to belittle in any manner the contribution made by the members of the Constituent Assembly. On the other hand, if you look at the history of these amendments, there are various kinds. Like the first amendment brought in Article 19(2), for instance, 8 heads of legislation, lawmaking, under which you can place reasonable restrictions on fundamental right under Article 19(1)(a). that was necessitated by a judgment of the Supreme Court. Similarly, various judgments of the Supreme Court have contributed to the need for amending the Constitution. That apart, the Parliament, when it sits in its sovereign capacity, which means when it is amending the Constitution, following the procedure in Article 368, feels felt necessities, because that is what Parliament is all about. They know at the grassroots level, they know what is the change which is required at a given point of time. Of course, it's not a healthy sign to have many amendments. It could be said that one of the qualities of a good law is its durability, uniformity, that it stays. Our constitution, like any other constitution, is intended to endure for ages, eternally, in fact. Because we can't think of a constitution which is for a limited period of time. The preamble to the Constitution, because we begin at the beginning, is like any other preamble to a statute. It is the key with which we open the mind of the maker of the law, which is the founding fathers in the case of the Constitution. The preamble recites that we, the people of India, give unto ourselves, resolve that we give unto ourselves what? A sovereign, democratic republic. The word socialist and secular were not included in the original Constitution. It was brought in by the 42nd Amendment with effect from 3/1/1977. The goals with which the founding fathers enacted the Constitution are briefly but beautifully captured in the words of the preamble. To secure unto ourselves justice, social, economic, and political. So justice as a concept is all comprehensive because it encompasses all possible aspects of justice. Then we move on to the next goal, namely equality. Equality in status and opportunity. Liberty of thought, expression, worship. And then, last but not the least, to foster fraternity and to ensure the dignity of the individual. Much of it can be traced back, if you go back in point of time, in legal history, the rights of man, the Universal Declaration of Rights of Man in 1789 under the French Constitution. You can go back to the Declaration of Independence in 1776, the United States Declaration, where they start with the words, it is self-evident that man is born with the right to life, liberty, and the pursuit of happiness. Different constitutions across the world put it differently. But some of the ideals are immutable, permanent, cannot be changed, and they are equality, liberty. Equality and liberty. And it is following the path of equality and liberty you reach the goal of justice. And added to that, all of this can be achieved only through the forging together of fraternity between so many different sections of people as we have in India, belonging to different religions, speaking different tongues, hailing from different areas, having their own social, regional histories, habits, folklores, music. So many varieties. In fact, nobody can be lecturing India about how we solve the problems, of course, in terms of the humongous problems through which our governments from day one, we were in fact written off as incapable of achieving democracy. I'll just, as an aside, go to tell you what had happened in our neighboring country, Pakistan, which was also created under the Indian Independence Act. They also had a constituent assembly. The first constitution was drafted in the year 1956, much later than our constitution, which came into force in 1950. The Constitution lasted only for 6 years. Military intervention, tussle as to where the power center should be, whether it should be the president, military. 1962 saw the birth of the second constitution for just 6 years after the first was adopted. Even that is not the end of the story, because you have the third constitution, which now governs Pakistan, which was drafted, which came into force in 1973. So the Indian constitution in that sense has been around, and though it has been tinkered with through lawful amendments 108 times, but it's still there, live and kicking. Now, we talked about preambular ideals of liberty, equality, justice. The Supreme Court has held in Berry Union that the preamble is not a part of the Constitution. The Keshavanda Bharati corrected that and said preamble is very much a part of the Constitution. It is amenable to be amended. But it has been made clear by Chief Justice Sikri, if you read the decision Keshavanda Bharati, that the values of the preamble, like equality, liberty, justice, can anyone say that they can be amended? Can you, for example, today say that we will not have Article 14 from tomorrow onwards? If an amendment is brought, it will suffer from stillbirth, because, of course, in Kohilo versus State of Tamil Nadu, a 9-judges bench has held that Article 14 by itself constitutes a part of the basic structure. So these are values which transcend time and space. They are natural, primordial rights, as has been held in Keshavananda Bharati. And I would request you to read paragraph 136 of the privacy judgment reported in 2017 10 SEC page 1, wherein the court has reiterated that there are certain primordial ideas which can be traced to natural law, natural rights. They are natural rights, like right to life, right to liberty. It is not the bounty of the state. It has been held in the privacy judgment that the states do not grant you these rights. The states are confirming these rights. These are rights which are self-evidently, naturally belonging to you by birth as a human being, cannot be taken away. The preambular values have been fleshed out actually over various articles, because there's no point in having a preamble if the body of the Constitution doesn't give life to it. So we have the concept of equality being fleshed out over Articles 14 to 16. Article 14 speaks about equality before the law, which represents the concept of rule of law, borrowed from English jurisprudence. The second part of Article 14, namely the equal protection of the laws, is borrowed from the 14th Amendment to the US Constitution. Our founding fathers strived hard, deliberated very vigorously, borrowed from various models across the world. And therefore you have 14 to 16 embodying the ideal of equality, which has been indicated in the preamble. Coming to liberty, again, you find it expressly enumerated in freedoms in Article 19 and Article 21, which again speaks of the prohibition against life and liberty, personal liberty being deprived except in accordance with the procedure by law. Then you have the concept of justice. Now, I may just, as I remember it, tell you, Article 17, for example, speaks about the abolition of untouchability. Article 25(2) of the Constitution gives power to the state to make laws so as to throw open public religious places belonging to the Hindu religion to public worship because of the problem of untouchability. The court has held in Nagraj, 2006, that it constitutes the value of social justice, because fundamental rights also have been conferred not for the benefit of enjoyment of the individuals per se, but to subserve the sublime object of reaching social justice to the community as a whole. Of course, the major part of social justice, political justice, economic justice is more vividly, descriptively captured in chapter 4 relating to directive principles. Though they are not enforceable as expressly declared in Article 37, they have been declared to be fundamental in the governance of the state. Now, how is it fundamental? 3 ways. To begin with, the courts have held that all state authorities must bear in mind the directive principles when they embark upon any action, be it the executive, be it the legislature. The judiciary also must bear it in mind. It has been held in Minerva Mills, as you know, that you cannot trump fundamental rights by taking the directive principles route. In other words, in the case of a direct conflict, it must be the fundamental rights. Every effort is made to reconcile, to interpret them in harmony. Now, the second way in which directive principles have gained ascendancy from at least, particularly in the mid-80s, a law is made under Article 19 purporting to carve out a reasonable restriction, place a reasonable restriction on a fundamental right. If the state pleads that it is to give effect to a directive principle, the courts will readily accept it. Another way in which the directive principle has proved its utility is the case of Unnikrishnan. The court held that the right to education is a fundamental right. Now, how did the court get there? The court actually sought inspiration from Articles 41 and 45 of the Constitution. 45, in fact, spoke about the duty of the state to provide education till the child attains the age of 14 at that stage. Now it has been recast, as you know. The court said that the right to education being itself so important, transcendently important, that it must be treated as one of the unenumerated rights in Article 21. In other words, the Constitution can speak through its silences as much as it does through express words. There are rights which the courts have been on an odyssey right from the beginning to discover and declare. The right to education was one such right. And therefore, the directive principle played a huge part in the discovery of a fundamental right, a new right, as it were, in the conditions in which our country is, and particularly having regard to the thought and ambition of our founding fathers that to bring about a socio-economic political transformation through the Constitution. The Constitution is just not a legal document, mind you. You remember the words of Justice Holmes, who said that, be you always remember that it is a constitution that you are interpreting to the courts, that a liberal spirit must inspire those. Task it is to interpret the Constitution. So we have this third utility of the directive principles, although they have been, there are two wheels of the chariot. And if one of the wheels is weak or not balanced properly, not if given effect to properly, the chariot will not move, the nation will not move. This is the central idea of the principles of directive principle. Next I move on to chapter 4a, a much ignored chapter, namely fundamental duties. One of the fundamental duties is, obviously to begin with, that it is the duty of every citizen to abide by the Constitution. Now I asked myself, I just thought, what do you mean by abide by the Constitution? First of all, how many of our people know about the Constitution? How many who live in the distant villages, of remote villages, who have not had education, do they even know that we have a Constitution? But at least for those who know about the Constitution, my understanding is this. You have to respect the Constitution for its various provisions, the institutions it has put up, namely the organs of the state, the procedures that we have, constitutional morality, constitutionalism, because you have many countries which have constitutions which have floundered, folded up, because they have not observed constitutionalism. Now, I thought that Constitution means also the laws which have been made under the Constitution. Therefore, it is my proposition that the constitutionally imposed fundamental duty to abide by the Constitution means that each citizen must learn to obey the laws of the land. We recently came across the horrific incident of that 17-year-old who drove the car. He obviously didn't have a license. If reports are true, he was drunk. The laws in Maharashtra prevent serving of alcohol to somebody who is below 25 years. He is 17 years. Because we have a problem with growth. And some of the children that you may not be able to find out. And nobody is expected to ask for an identity. But what I am saying is at least 3 laws were broken. Even today when I came by the Chittoor road. So we have this no right turn. Immediately after there is a bridge. Every soul, everybody, be it a small vehicle, a big vehicle, everybody observes the law in its breach. Brazenly. Is this how we observe? Is this how we pay obeisance, respect to the Constitution? By disobeying all the laws? If you disobey all the laws, what will happen to the Constitution? Because the Constitution itself is based on rule of law. And how do you observe the rule of law if you break the laws on a daily basis? If a public servant takes a bribe, is he paying obeisance to the Constitution? No. If you who are studying, if you resort to unfair practices in your exams, are you observing the Constitution? No. I would therefore urge that along with fundamental rights and directive principles, it is as much important that the citizenry must learn to become law-abiding, obeying the Constitution, constitutionalism. Please drill it into yourself. Whether you become lawyers, whether you become judges, whether you become employees, it's a pursuit of law, and the study of the Constitution should instill in you this fundamental quality. In fact, I can tell you that since I am also working in a capacity where I deal with human rights, there is a very stringent criticism of the Western model of human rights. Mr. Nambiar, he has written a wonderful article, and also one Vikramjit Banerjee, if you are interested, you can read it in 1990, volume 1 SCC, page 1, journal part. It speaks that the Western model, it's rights-centric. You talk about obtaining rights, it's all good. What about duties? The question is raised. And the dharma of the religious texts of this country speak about duties also. So it is your duty to obey the law. Next, another fundamental duty speaks about remembering the values of the freedom struggle. Each generation must remind itself the struggles through which our forefathers went through, millions of them going to jail, dying, suffering physical assault from the British police. All for what? Each generation must therefore remind itself, may have a go back to those glorious days as we see today. This is the second thing that the fundamental duties talk about. Again, the fundamental duty speaks about ideals of common brotherhood, irrespective of religion, caste. No, how many of us observe it in our spirit, in the underlying, the major premise? Is it subconsciously, consciously, in every which way present in our minds? Are we really dedicated to the Constitution in all these ways? These are some of the thoughts that I would like to leave you with on this auspicious occasion. Having spoken about the fundamental rights, I'll just say a few things more about how the Supreme Court has shaped the Constitution through its various decisions. Supreme Court of India is recognized as the most powerful court in the country. Not because we have the highest population in the world, but because of the way in which it has impacted the destinies, the lives and destinies of 1 billion plus people. In A.K. Gopalan, the majority took a rather restrictive view of procedure established by law in Article 21, as you know. Over a span of 25 years, by the time it reached Maneka Gandhi, the court has discovered the trinity of Article 14, 19, and 21, rather than an isolationist, island-like treatment of Articles 14, 19, and 21. The Supreme Court, another judgment which I thought was important was the concurring judgment of Justice Matthew in Sukhdev Singh versus Bhagath. It opened up the doors to many people to go after arbitrary illegal actions by the state in the form of instrumentalities. So now, then of course we have the celebrated judgment in Keshavananda Bharati. Therefore, we are talking about Constitution in changing, and Constitution and change. The one lodestar which cannot be wished away is not just the Constitution, but the basic features of the Constitution. There are many features which have been discovered, like democracy, rule of law, secularism. These are the contributions of the Supreme Court. Now, I can tell you from personal experience that Supreme Court judges function in terrible conditions, if there is no better word for it. On Mondays and Fridays, if any one of you has been to part of the office as an intern, you will know the kind of horrific lives which only the wives of the Supreme Court judges and our personal staff get to know. They work hard, and work hard is an understatement, a very mild understatement. Their contributions are not to be, undermined or belittled. Justice Krishna Iyer, along with Justice Bhagath, started the public investigation movement. Something which is, theoretically very difficult for the Western juristic world to understand, but they have come to appreciate it because the Indian conditions required it. So a letter sent to Justice Krishna Iyer by a fellow prisoner alleging torture of somebody in solitary confinement triggered off something which has become today a legendary judgment, the rights of prisoners. This is what the Constitution will carry meaning to the teeming millions, not for the well-to-do, but for those whose fate it is to go through the rigmarole of a criminal investigation or trial. Various aspects of Article 21 relating to prisoners' rights have been discovered in Article 21. Supreme Court has gone on to declare the right to free air, pure air, environment, like the right to education. One positive development is when the court declared in Unnikrishnan in 1996 that there is a right to education. The dialogue was set off between the judiciary and the legislature. Finally, it culminated, as you know, in 2010 with the passing of the Right to Education Act, guaranteeing the right to education. Article 21A was inserted by the 86th Amendment. And now you have Article 41 recast that the state shall try to provide education for children up to the age of 6, because 14 is not necessary, it has become a fundamental right. and remains no longer a fundamental, a directive principle. Similar contributions by the Supreme Court in the field of personal liberty and life within the meaning of Article 21, consisting of various judgments, kicking off with the NALSA judgment relating to transgender, rendered in the year 2014, where the court, by a dynamic interpretative process, interpreted the word sex in Article 15. You cannot have discrimination only on the basis of sex, is one of the forbidden territories. The court said that sex has two meanings. One is a biological meaning, that you are born with certain, in a particular way. But that is not the end of the understanding of the word sex. It also means, what do you mean by gender of the person? So the court came to recognize the third gender in place of the only binary of between male and female. It led to the 2019 Act by Parliament. So this is how the courts have been contributing in terms of development of the law and principles which will finally lead to the fulfillment of the goals in the preamble. This judgment was later, I may just line up is the privacy judgment came in 2016-17, where right to privacy was declared, not as an absolute right. None of these are absolute rights. The stage was set for revisiting NAS about the criminality of homosexuality in section 377. The court went on to make use of the privacy judgment. It came as a big help. And the court said, yes, it's a part of privacy. What happens in a room between two consulting adults as to what kind of sex they should practice is entirely their decision. It's part of personhood, an autonomy, the concept of autonomy, personal freedom, the right to act. Ultimately, you should recall that one of the fundamental principles of liberty can be traced way back to Cicero and Mill, wherein they propounded the harm principle. Harm principle is the state has no authority over the province of an individual, the conduct of an individual, and their right, the power of the state begins and ends with the area where your actions can cause harm to somebody else. Of course, that is not fully correct now. I'll give you the illustration where you're asked to wear a helmet. It is actually, I can say, it's my life, I can do whatever I want with it. If the law says that you cannot travel on the footboard of a bus, that is again meant to save you. So we have said goodbye to absolute theory of harm principle. The subject matter of legislation can be just protecting the life of somebody. Of course, it has indirectly an impact on the lives of your dependents. That way you can say it fulfills the harm principle as well. Now, what is the goal, primary goal enshrined in the preamble? I said justice, social, economic, and political. Let us take, to begin with, economic justice. What are the relevant provisions in the Constitution which spell out the right to justice or the concept of justice? They are essentially contained in Articles 38 and 39, which are directive principles. They are not directly enforceable. Just have a look at Article 38.2 of the Constitution. Article 38.2 declares that it shall be the duty of the state, within its constraints, to minimize inequality in income. Let us just look at what is happening in our country now. A study has been conducted by what is called the World Inequality Lab. And an article has been written by 4 authors, led by Thomas Piketty, an economist. You can read it, it's available on the YouTube. I would urge you to read it. The figures are startling and shocking. In 1951, just immediately after we became a republic, and we had sworn to bring about social justice, and Article 38(2) says that you have to reduce inequality. The income of the top 1% of the adult population in India was 11.5%. 11.5%. India followed a socialist path because during the time of Mrs. Gandhi, till about 1982, we were on the socialist path with full fervor. So in 1982, this 11.5%, it came down to 6%. Now, where do we stand today? We are talking about change and the Constitution. So today, we stand somewhere like this, as per the report. 1% of the Indian population gets 22.6% of the national income. I'll repeat it. 1% of the Indian population, top Indian population, takes home 22.6% of the national income. The same 1% of the Indian population controls 40.1% of the national wealth. What is the position of the bottom, the middle? The bottom 50% of the Indian population take home only 15% of the national income, as contrasted with 40% going to 1%. The average income of the adult population in India, of the 50%, is 71,000 rupees yearly. That breaks down to nearly less than 6,000 rupees in a month, and again on a monthly basis is less than 200 rupees per day. I'm talking about 50% of the India's population. This is the condition. Now 40% of the middle income, middle group, they were said 5, 10, 10 and then 50, they get 1,65,000, which is less than 14,000 in a month. So something close to 15,000 per month is the monthly income of the vast majority of Indians. So there has been a change. 11.5% earned in 1951 by top 1% has grown to 22% after there is a sharp decline in 1980 during the socialist era. Now, what does it indicate? This indicates that as far as economic justice is concerned, though there has been a change, the change is not for the better. The change, if you want to talk in terms of there being no change, indeed there has been no change in terms of it being better, whichever way you interpret it. But the statistics cannot be wished away. This is part of empirical evidence which has come. In fact, you have the extreme poverty index brought about by a world body. And today India is supposed to have extreme poverty, which is below 3% of the population, which still constitutes about 3.44 crores of people. So why I am bringing up all these things is, if you look at the economic justice system, the economic justice aspect in the preamble and flushed out in various provisions, it would appear even after 75 years, we do not think to have achieved enough. Because if you do not achieve enough for each individual, as Gandhiji said, it's a duty, it's my duty to wipe out the tears out of every Indian eye. So it is not good enough that a few minority is making money better, is one aspect. Now, Ruchir Sharma is a banker and he has written a number of international bestsellers. One of the books he has written is about the rise and fall of nations, in which there is a chapter on inequality. He talks about the billionaire Raj. The billionaire Raj, he says, we have 3,000 of them in the world. And India is number 3 in the number of billionaires after the US with about 800 billionaires, and China is the second, and India has 200 billionaires. Now, billion is obviously a lot of money. In fact, what does it signify? So economists say that if you have a lot more money than you really need for your basic needs, what happens at the economic end is there is the marginal propensity to consume declines, which means that unless you have enough loss to spur the reinvestment of this money, extra money, into productive areas, it goes waste because they are not going to spend money. They have whatever you need, they have already got it. So this is going waste for the economy. In fact, I read also that the G20 countries, Brazil, Spain, Germany, and South Africa, India is also a G20 member. They have come out with a proposal that you should have a super tax at 2%, which will yield a whopping 250 billion sterling pounds, which can be better used for much needed public causes for the poor. So the problem with billionaire Raj, again, Ruchir Sharma would say, you have got the good and the bad kind of billionaires. You have the billionaires, who have heirs to family fortunes. You have them investing in areas like real estate, gambling. They make their money. There are the good millionaires who actually, particularly the tech companies, innovative ideas actually are brought forth, and if they make money, it's good because ultimately it leads to greater productivity and use to the economy. Now look at what the employment figures are. And there I would turn to Dr. Raghuram Rajan, the former director of the RBI, who, in a recent interview, and a great economist also. What does he say? He says that you have the specter of 16 million Indians, 16 million of your brothers and sisters, applying for 60,000 jobs in the railway. You have PhD holders lining up with their applications to be appointed as peons. Now, what does the law say? Article 39A speaks about the duty of the state to secure reasonable means of livelihood. So where is the state? What is the state achieving? In fact, Raghuram says that there has been growth. In fact, he would say inflation adjusted and flaws adjusted, it is growing at about 6%. India is growing at about 6%, not a bad. Like Germany is growing, I'm told, at 0%. Japan is growing at 1%. So because that they have already reached the stage of development. So poorer countries will grow at a much higher rate. So he says it's much below 9 to 10% at which China grew. And we talk about the population dividend, and that we'll become a superpower a developed country by 2047. So he says time is running out if you don't grow fast enough, because by that time the population dividend will die out, because they will lose their youth and you will not be able to attract capital on that basis. So he said you must grow more, and the proceeds of the growth should be distributed equally. And there he speaks about what? He speaks about the fact that there are twin problems regarding employment, apart from pointing out hues. One is employable youth. Employable youth means he talks about the education system which should be blamed. And by the by, education, our GDP, our spend on education is 2.9% of the GDP. Health is something like 2.5%. So unless, in fact, the blame is being put at the doorstep of the political leaders at the beginning of our republic, that they did not invest enough in education and health. It's fundamental, because all the other countries straight away plowed in a lot of money, and the result is there for everyone to see. So unemployment has two shades to it. One is that you do not have employable youth. You have a lot of people who have come out of the universities with degrees. But if, for example, engineers it is being said that if you come out, if you're asked to do a practical problem, they have no idea, because the textbooks which they are taught, they have outlived their utility. Therefore, you need to have skilling, as they have done in other countries like China, Vietnam, which are forging ahead of us. Second thing is, the actual unemployment is traced to the tendency to have more capital-intensive industries in the country. You get more profits if you have capital industry. You can dispense with labor. But he says that if you want to have a growth-oriented GDP number, because you must recall when you talk about India being at the 5th position and about to shoot up to the 3rd position in a couple of years or 5 years, you should not ignore the GDP per capita income, in regard to which India is at the 127th position in the list of countries in the world. 127th position. So if you actually, average it, what the top will be getting will obviously deflect our, mind with saying that, okay, we are doing so well. But what happens to the majority of the people? We the people, the real we the people. So he says, unless you have more labor intensive, and there is a problem, because if you are going to have labor intensive industries, you need to have labor also contributing it by their might, in terms of, the trade unionist attitude. I may be a little out of fashion and a little unpopular at saying it, but I am a little saddened. I was telling the principal about it, and the minister is not here. In our state, the minister was sharing with me, I hope I am not violating the right to privacy. She was telling me both her sons are in Canada. She's not alone. I know of so many people in Kerala. This is going to happen, that people are fleeing our shows. We offer them education, they get educated, they leave. Why? Because we are not providing them with the conducive atmosphere to start a business here or to get employment. So probably, if the trade unions, the politicians, I say it in absentia, the politicians, all of them sit together to make, particularly a state like Kerala, which has got immense talent in terms of human resources. We have 33,000 hectares of land only. I was told by somebody who knows it. In comparison with vast tracts of land available like in neighboring Tamil Nadu, which therefore hampers us in going in for regular manufacturing. One of the problems. But we can have industries. We should have our public offices, our public servants being more responsive, humble. And of course, there is no scope for corruption. Corruption and the Constitution cannot go together. When you talk about corruption, in England, for example, they claim that they have done away with the scourge of corruption about 150 years ago. I mean, where are we? We are talking about the 21st century superpower and still we are corrupt. I mean, unpardonable, unthinkable that you can take money. You can demand money, or you will delay things by your rights by, asking for money. So these are all part of your fundamental duties. I have already said that you have to obey the Constitution and the laws. Now, coming to social justice, so I've said about economic justice, this is the picture that we have in India. I'm not being cynical, I'm not being pessimistic. I love my country just as much as anyone else. But you cannot have your love for your country being conditioned by the imposition of a restriction that you will not be critical. I think my right to be critical of my country is a fundamental right, a natural right, which I do not surrender under the social contract theory, merely because others may not like me and I am in the minority. So develop a critical view is one exhortation that I would make. Now, coming to social justice, I've talked about economic justice. We have a problem. Social justice we have, we have to understand in terms of untouchability under Article 17, throwing open, that is one aspect of social justice. In fact, social justice is closely aligned with economic justice. I believe, I hope I am not wrong, Bal Thackeray, the former leader of the Shiv Sena, said there are only two castes in the world, in India, namely the rich and the poor. One of the ways in which you can escape the system of casteism, which I am sorry to say, perhaps is very pervasive in many parts of the country, not in Kerala as much as, I have been to Uttarakhand, I have served in Uttarakhand, in Delhi. Casteism is the prism, I say always, a prism through which you can look at any problem in India. The undercurrent, the underlying underpinning of any perception appears to be drawn from a casteist view, unfortunately. We have to outgrow that. That is the largest part of social justice. Political justice, yes. We have established universal franchise right from the beginning. Right from the beginning, the right to vote was given to women, unlike in the US, as the minister said. The Election Commission has done a fairly good job. Though of recent times, we have Supreme Court had occasion to flag certain issues relating to appointment procedures. But when you talk about democracy and political justice, it is not just about going and casting your vote every 5 years. Substantial democracy as distinct from formal democracy, according to Justice Aaron Barak of the Israeli court, which all Supreme Court judges quote, is more about various elements that go into make substantial justice, not just voting alone. For instance, immediately after the elections are over, they are voted to power. You should have a rule of law. You should have an independent judiciary. You should have respect for human rights, dignity, separation of powers. All these are features of substantive democracy as distinct from formal democracy. In fact, rule of law itself has two aspects. One is the regular, formal rule of law, that if there is a law, you obey it. Nobody is above the law, treat everyone equally. But the rule of law has been interpreted by the Supreme Court to mean virtually the same things as a substantive democracy. So virtually all these together, combined, you will find that ultimately the Constitution will come to your aid if we respect the Constitution. When you need it the most, the Constitution will be there for you, provided you are there at all times to support it by respecting it, fostering respect through your words and actions and what you do not do as well. Federalism in India. If you look at federalism, it has got various shades, and will take perhaps a few days to discuss about federalism, but I'll just see a couple of words and then I'll stop. Federalism actually speaks about, if you look at the historical federalism in India, from 1952 to 1967, we had single party rule in the sense that the same party, Congress party, ruled in the center and in most of in the states. So we had a kind of federalism because it was an internal matter of the Congress party, how the states' rights were ventilated. Thereafter, we have a period when you have coalition politics. And after 2014, we have returned back to the single party rule. I mean, single party, namely today the BJP is perhaps having power in various states, including at the center. So we are going back to. Now, I will only touch upon the aspect about the governors. I believe that the role of the governor must be strictly confined to the boundaries of law. So to begin with, I think that every governor should be taught the fundamentals laid down in Shamsher Singh, by the Constitution bench, as to what is the true role of the governor. He cannot intermeddle in the politics. He cannot be an agent of the central government. He must have a completely neutral stand. He does play a role. He has a role in terms of, in the matter of giving assent to bills and advising as an elderly statesman He can ask the state to reconsider any decision and things like that. But at the fundamental level, the Constituent Assembly debates clearly point out when they had different models of appointing him, including electing him and things like that. It was Dr. Ambedkar, allays all apprehensions by pointing out that whatever way you choose, he is only going to be a nominal head. He is only a constitutional head, and he is not really the political head. The ultimate power is with the Council of Ministers. So this is another aspect. There is a fiscal federalism, which is again a huge topic, which I do not have the time to go in. But these are all areas of worry. The next topic is secularism. Secularism was slipped in by the 42nd Amendment into the Constitution. Apart from the amendment which the minister spoke about, that in the name of God, one of the members, in fact, incidentally, very interestingly said that, before we the people, and he said, when somebody said in the name of God, another member responded by saying, if you should also add in the name of goddesses also. Finally, both these amendments were defeated. Two amendments were, in fact, moved in the Constituent Assembly debates to include the word secularism, but that was not done because members actually proceeded on the basis, particularly in the aftermath of the partition, that India was going to be a secular country. Now, when you talk about secular country, it's got different shades of meaning across the globe. It means different things in, for example, a country like France, which has got the strictest model. As distinct from in the US, you have the wall of separation, as you know, because of their very, very long history of fights between the church and the Western model between the state. In India, it came up a consideration essentially in the Saint Saviour's case, where one of the judges said that it's strictly, we don't have the wall of separation as we know it. But Justice Khanna went on to hold that it essentially means that all religions will be treated equally. It was in the decision in 94 3 SCC page 1, 6 page SCC 1, Bommaya, as you know, which enabled court to interfere in cases of Article 356 for the first time, unlike the state of Rajasthan judgment. The court went on to hold that secularism is a basic feature of the Constitution. In para 135, Justice Jeevan Reddy, I would recommend that you read. Justice Jeevan Reddy goes on because, the context of the case was many of the three state governments, the BJP came to power in the aftermath of the destruction of the Babri Masjid. Now, after they came to power, being voted on the BJP manifesto, one of the creeds was they will construct a temple in place of the destroyed religious place. The government of India decided to dismiss these governments under Article 356. So saying that, the RSS came to be banned. I think it was the fourth time RSS was banned. The members of the BJP led ministries refused, according to the governor's reports, to give effect to the ban. This led to the 356 proclamation. The court in paragraph 135 says that in India, that is a secular country, you have treat equally. More importantly, the political parties must be secular. Political parties must be secular, and the court says that you cannot have a de facto reversion to a state religion. Officially, as you know, India is not a theocratic state, unlike Pakistan. So you have to also, by your actions and words and what you do not do as much, observe principles which protect the concept of secularism. The more important part is section 123(3) of the Representation of People's Act 1951. It's been a subject matter of a number of decisions. It simply says that if a candidate or his agent or anybody with his consent makes an appeal on the basis of his religion, the word his has been the bone of contention in a number of judgments. The court, in fact, came to consider this question in the Hindutva cases reported in 1996, Volume 1 SEC, starting 169, 205, etc., etc. That in the first case, the court went on to hold that Hinduism, use of Hinduism and Hindutva may not amount to a corrupt practice. The reason being the earlier judgments of the Supreme Court which dealt with Hinduism as a religion. Hinduism is one of the greatest religions. There can be no doubt about it. Hinduism has been considered as a way of life because there are different shades of it. You would be advised to read the book, The Hindu View of Life by President Radhakrishnan. The contributions Hinduism has made to the metaphysics of the world is unique and is unparalleled. The court thought that this was the religion, this was the Hindutva that was being spoken of. But I have in my, I gave a lecture on secularism where I have pointed this out and I reiterate. Perhaps the court did not have occasion to deal with the work, the writings of Savarkar. Savarkar, and thereafter was the Hindu Mahasabha, and then you had the Gavalkar, that is a RSS, which was founded in 1925. They have given a different spin to it. Essentially, it would amount to, giving the minorities a kind of a place, a pedestal, as I would have put it. Now, whatever they have done, once the Constitution has come into force, any right or duty or liability or power which is inconsistent with the provisions of the Constitution can have no legs to stand on, is my view. Whatever we have undergone, we have drawn the curtain down. After the Constitution, all are equal. Religion and race and caste and place of birth, unless they are relevant, have been declared irrelevant. So we forged together only on the basis of that kind of a fraternity. So I would say that I would criticize the judgment of the Supreme Court. I have said that already, that the judgment in the Hindutva judgment did not consider the Hindutva according to both the Savarkar and the RSS version, which may take it, make it inconsistent, completely inconsistent with the Constitution of India. Though an attempt was made in Abhiram Singh versus Kumachan, that is in 2017 SEC, the 7 judges bench have now sealed the fate of our section 123(3), and they have said that appeal based on the religion of the candidate or of his opponent or of any member of the audience is forbidden. And religion has no place in an election campaign. Now, an appeal to religion, the Supreme Court has held, is a matter to be decided on facts and the words which are used in the election speeches. I will go further and say that, you would have to understand that the politicians are very well aware of their limitations, that under the Act, they can be proceeded against both under the model code of conduct and also under the law, if after the elections are over. So I would say that if they adopt expressly or impliedly any practice, anything which they do, which will immediately create a religious identity and will fetch them votes, because I believe that the means are as important as the end. Gaining political power can only be a means to serve the people. The means by which you get political power is as important that it should be done in a pure manner, at least going by the laws of the land, obeying the laws of the land. Now, the laws of the land are very clear that religion, race, language, if some of them uses caste, there also I would say, somebody using caste to get votes, that is forbidden. And the election commission must come down heavily. Whoever it is, however high he may be, they should do it in time and they should not keep matters pending. If you do not do that, they are doing the greatest disservice to the Constitution and the founding fathers. This is what I would say about, secularism. Another area of, change that is taking place in the Constitution, under the Constitution, is freedom of speech. Now, when I say freedom of speech, I'm going to link it with the presence of the media houses. Today we have the visual media capturing the imagination of most of us. In the Abbas judgment, way back in 1970, in regard to censorship, the court has held that the visual media is very powerful, unlike the print. By the time you read one page of a newspaper, it will take time and it will sink in, and then you will think. And if you see moving images to the accompaniment of sound, it is a powerful image on you. Now, today, the visual media reaches virtually every home, Indian home. Nobody is there without visual media. So they got a very powerful control over the Indian minds and hearts. Now, what is wrong with it? I saw a video where Sai, who is a Magsaysay Award winner, he says that the media has become a $1 trillion industry. It has become a business. It has become a business. So it is business considerations which are supreme. They subordinate their journalistic duty to the urge to earn more and more money, TRP. The second aspect is the impact of ownership control. Now, business houses controlling the media houses, there is a tendency that they will toe a line which will be perhaps dictated to them by their editor, whoever it is, and ultimately tracing the line of control to the management. So the management will have other businesses. Now, the government of the day is powerful. So if the government has a stranglehold over them in terms of controlling their business fate in regard to their other businesses, the media will fall in line. They will surrender their freedom. They surrender their duty, more importantly. Now, why is it that I say that a fundamental right is, the Supreme Court has held in 1995, please look up, I think that is Secretary Information and Broadcasting versus Secretary West Bengal Cricket Board. There the court has held that the media, the press, as you know, the press doesn't have an independent fundamental right. It is part of 19(1)(a), whatever is a fundamental right. The freedom of the press includes a right to inform, educate. They can propagate their ideas, provided in accordance with the program code. You have a program code which is statutory in nature. The more important thing is actually it is the fundamental right to the listener, the reader, if it's a case of print, to be informed, educated. Now, why? What is the importance of this? This is important because the right to know itself is a fundamental right under Article 19(1)(a). If you do not have the right to know, how will you express your ideas under Article 19(1)(a)? How will you participate in the democracy? It's your duty as a citizen to participate. Unless and until the stream of information which comes out from the media houses is pure, which means that it is unbiased. That you don't do something with an agenda to help anyone or to destroy another political party is what I intend to mean. Unfortunately, very large sections of the media are doing just that. This is a phenomenon, this is a change which within the meaning of our discussion, which has a gross impact on the working of the Constitution. Because it has an impact on the electoral system itself, how governance is held. Who will question the people who are governing us if the media does not take up? It is being said that it is not the role of the media to play the role of the opposition. I say that it is not I also say it is not the role. But there is a point of coincidence. There is an area where it becomes actually an interplay, in the sense that there are issues which matter to the common man, which it is a duty of the media by itself to actually raise. Not that whether the opposition is going to raise or not. Independently of the opposition, it's a duty of the media to raise. Such issues, it is a duty of the media to ask. For example, if in one voice, I thought what is happening in Manipur, if they had, gone on, non-stop, like for example, right now, there, if you see the media, you'll find that the incidents in Pune is being played up. Everybody, every media, they will coincide, they will come together. If they did that in respect of Manipur, they would, I don't know what, perhaps much better things would have happened. So the anchor, next aspect is the anchor and the right, fundamental right. What is the role of the anchor? How does the anchor conduct the show? I have been shocked, watching some of these media. My relatives tell me, why are you watching it? I watch it with the hope that one day they will reform. Because I want a, a resilient, healthy media. So the media, what they do is, they will mute somebody who wants to make his point. You are violating his fundamental right and my fundamental right, because the point that he wishes to put across may be my point. He'll be speaking for me. You mute him. Then when he is asked a question, there is a body of follow-up questions. Because the reason is that the anchor is actually having an agenda because he's asking these questions on behalf of somebody else. He's having a political bias, and therefore he'll follow it up. When you ask the other side of the picture, he'll be very, sitting on the edge of the seat with the greatest respect, and you will not have any follow-up questions. You will not mute him. It is all ears. Now, all this is going down to the audience. It has a huge impact. Now, there is a program code, there is a broadcasting authority. They are occasionally, they do visit them with punishments. But there should be more to it. And there I bring up one judgment of the recent judgment of the Supreme Court, and I hope people like you will come forward to make use of it. That is the horizontality judgment in Suresh Kaushal. The Supreme Court, the Constitution bench in 2023, in Suresh Kaushal, just you can get it, was faced with a question as to whether Articles 19 and 21 of the Constitution have horizontal operation apart from vertical operation. As you know, vertical operation is when fundamental rights are enforced against the state, ordinarily, and officers. You can't file a writ petition under Article 232 or 23 against a private individual. The court has held, importantly, that the fundamental rights under Article 19 and 21 have horizontal operation, which means you can enforce it against your fellow countrymen. Somebody takes away your right. So I was just thinking, if somebody were to go to court directly, just making the media houses a party, make use of the Kaushal judgment, and say you are violating my fundamental right in the manner which I have described. I mean, I don't know. There are future issues that that might come up as a follow-up of Kaushal judgment. Now, some of the political changes that I foresee, three, which might be of great importance. The first is one nation, one election theory, which has been touted by the party in power. Now, it has a background. The first election was held in 1952, as you know, general election. It was followed up by the election in 1957, 1962, and 1967. In all these four elections, actually, we had one nation, one election. This is not a new idea. In other words, elections to the parliament and to the state legislatures were held at the same time. Now, the party in power today says that it will be brought back. It is intended to be brought back. This is, I think, one of their official promises, I think. It stopped in 1968 for some reasons, and then it has been not followed up. There is also a report by the former President Kovind recommending the holding up because it will lead to probably saving of about 5,000 crores or 10,000 crores. Now, there are various objections to this. If you introduce this, we have another, I have no other word for the horrific practice of defection taking place in our country. The practice of our elected representations having no morality, to be bought like chattels, to switch their religions midstream. And the only way you can get them is under the 10th schedule. the kind of money that changes hands reportedly. What has happened? We are discussing the constitution and the changes. One of the biggest changes is the kind of, the lack of morality that is shown by our public representatives. Where when defection takes place, kindly consider the train of events that are set in motion. A democratically elected government is booted out. They fail to fulfill their promise for obvious reasons because they are not given the opportunity. You pay obeisance to money power and you lose all that. Now, if such a thing happens after one nation, one election comes into being, what will happen if such a thing happens in a state? Under the law as contemplated, if it happens within 1 month of a democratic election taking place, they'll have to wait for the whole 5 years. President's rule will come. You want that? Is that in consonance with basic democratic ethos? I would think not. It's a matter to be seriously thought of. The future lies in the future of the law itself, namely you. You will come up, with solutions and thoughts about this. Another area of concern which is going to come up is, surely going to come up is, delimitation, the context of federalism. As you know, Article 81 speaks about proportional representation based on states. So in 1973 was the last census, and it was put off, holding a census and then deciding the boundaries of the constituencies, the number of constituencies was put off for 25 years. Bajpayee also put it off again for another 25 years, and that period is going to end in 2026. Now, when that happens, those states like Kerala, Tamil Nadu, are going to end up losing the number of constituencies they have. States like Bihar and Uttar Pradesh, where population has not been controlled in the manner we have controlled, population has grown, they will end up having more constituencies. Now, what will be the state of the federalism in India? What will happen to the concept of Union of India as was contemplated? This is again a matter which will have to engage whoever is going to be in power. When the time comes, either you put it off or whether you soften it up, by moderating it. You have to do something. Good governance, upholding of the rule of law, constitutionalism, constitutional morality, a fearless, independent and totally honest judiciary are the rights of the people of India. When I talked about the judiciary, I thought I can end with that. I have only a couple of things to say about the judiciary. I have already delineated, it's done a great job. It is indescribable to those who do not have a personal working relationship with the actual courtroom, the kind of work they do. I have only, in fact, a few suggestions. The first suggestion I have is that you should have a permanent constitution bench. We have 34 judges today. If you have a permanent constitution bench, those matters which are brought up before the constitution, which are referred to the constitution bench, it should be heard, in my view, and decided within a period of 6 months at the latest. Otherwise, they will keep, cold storage. You cold storage it, and then finally when it is taken up, it gives rise to a lot of, cynicism and finally distrust and lack of confidence. This should not happen. The kind of criticism that we get to hear can be avoided if you have 5 judges on a rotating basis. And here I would like to, personally, on a personal note, I would like to acknowledge Justice Uday Lalit, U.A. Lalit, because it was during his term, he was so just and kind that he distributed the constitution benches among the judges. So it led to the liquidation of a decision being taken in many of the cases early, and also giving an opportunity to the judges. You see, ultimately, what you do in life largely depends upon whether you get an opportunity. And secondly, when you get that opportunity, whether you're ready to rise to the occasion. But without being given an opportunity, which is what, we have the whole constitutional principles of equal opportunity. So that is one thing. So having a permanent constitution bench that no matter should be kept pending for more than 6 months. The second thing is about the working of the collegium. I was also a member of the collegium. You know the 2 judges case. The net result is the Supreme Court makes the proposal. Government takes a decision either to accept it. If it is accepted, it is usually being acted upon 2-3 days. I've seen some of the cases. Some of the cases are kept pending for a long time. The story for another day. If it is not accepted, they come back to the Supreme Court collegium with their remarks. The Supreme Court either accepts it or Supreme Court reiterates it, says that you should look into it and it is to be done. No, it is, at this stage, I have felt that many names are going to cold storage. Many names of persons whose names have been reiterated. Under the law, the government is expected to immediately appoint. Government just simply responds by saying nothing. Virtually it doesn't say anything. It is a resounding silence. I would personally like to recall the name of one gentleman who I think from Uttarakhand was my chief standing counsel, whose name was reiterated. I thought he was a fine lawyer, a fine gentleman as well. I don't think his name has been, there are many like them, I think. So I believe the solution can be only if the court tightens its grip. The court may have to take suo motu proceedings. Even if it is in the region of contempt, if that's the only way out, for once, the matter must be settled. That this vacillation, this dilly-dallying, delaying, which finally results in fine members of the bar being ultimately posed with the threat that finally they will not be, their name will be cleared. That's not good for the country. Now, I would also say, while on I think I have said it sufficiently for the purpose. I think I have overdrawn and overstepped my limits. I believe, I'll end on a positive note. India has everything to actually truly make it the great country that it is. We have a great civilization. But the Constitution is supreme. Whatever the changes that may take place, our Constitution is like a set of vessels into which each generation will pour their concerns and meaning. And you will finally end with justice, which is socio-economic and political. Whatever is declared in the preamble. The Constitution is indeed a durable document. We have the safety mechanism of the basic structure so that, a constitutional amendment will not have the effect of mutilating the Constitution or defacing it, as was the worry. I wish each one of you the very best. And I would end by saying that the future of the country, it is not some kind of, I am trying to flatter you. The future of the country literally lies in your hands. It is if your hearts and minds are not ignited by the magnificent provisions of our Constitution as interpreted by the Supreme Court, I do not know what will happen to the country. Jai Hind.
Thank you for your illuminating words, sir. Now, we'd like to present Justice K.M. Joseph with a memento to mark the occasion. Our principal, Dr. Bindu M. Nambiar, will present him with the memento. The Justice reminded us that true equality can be achieved only by fostering fraternity among various communities across India. It is indeed an important reminder in today's increasingly polarized world. Now, I invite the State Attorney, Advocate Manoj Kumar, yet another alumnus of this institution, to deliver the keynote address.
Dr. Bindu M. Nambiar was the president of the function. Shri P. Rajeev, Minister of Industries, Law and Coir. Justice K. M. Joseph, former judge of the Supreme Court of India. Mr. Isa Farhan, chairperson of the College Union. Advocate P.T. Girijan, PTA Vice President. Dr. Mini Paul, Dr. Premji, Ms. Sanjana S. Kumar, Vice Chairperson, College Union. Dr. Giri Shankar, the Principal of the St. Dominic Law College, Kanjirapalli. Other faculty members, my dear friends. At the outset, let me express my pride and happiness in being with you today for this prestigious program at my alma mater, which has been nurturing ace legal minds for the past 1.5 centuries. I wholeheartedly congratulate the organizers of the National Conference for having carefully chosen the most significant theme in the current scenario in our country, the Constitution in a changing India. On the 26th day of November 1949, we, the people of the erstwhile British Dominion of India, adopted, enacted, and gave to ourselves our Constitution, whereby we solemnly resolve to constitute a sovereign, socialist, secular, democratic republic and the former subjects of an empire and its vassal princely states became citizens with equal rights. An arduous procedure was undertaken by the founding leaders of the country to create a republic that secured for its citizens justice, liberty, equality, and fraternity. The earlier unofficial attempts by the leaders of our freedom movement to draft a constitution for our country, whether it be the Constitution of India Bill 1895, also known as Swaraj Bill, widely believed to have prepared under the guidance of Sri Gopalakrishna Gokhale, or it be the Commonwealth of India Bill 1928, piloted by Dr. Annie Besant and Tej Bahadur Sapru before the British Parliament, or it be the Nehru Report of 1928, all of them envisaged ideals of equality for the citizens, freedom of speech, expression and religious beliefs, and universal adult franchise. Though our Constitution has certainly amalgamated concepts adopted from various other constitutions of the world, it also equally embodies within itself the values, ideals, and aspirations for which the country had struggled under the imperial regime. Even embraced foreign principles were adapted in accordance with our social and political environment. Our country is sovereign insofar as it derives its power and legitimacy from our Constitution, which in turn was adopted by we the people of India. Our country is socialist insofar as our Constitution mandates it to strive to distribute the common wealth of our country in such a way so as to subserve the need and the requirement of common man. As rightly told by our chief guest, even in our Constitution, under the directive principles of state policy, it was stated there is a provision to minimize equality. After 75 years of our Constitution, what is the stage? As rightly pointed out, the majority of the wealth is now with a less population, that is less than 10% of the country's men have the majority of the wealth of the country. Our country is secular in as far as our constitution provides that the state must not identify itself or favor any particular religion and must afford equal treatment to all the religions, sects and denominations. Our country is a democratic republic insofar as our constitution has adopted parliamentary form of democracy. Our constitution has endeared to the citizens of a country in protecting their rights against authoritarian deviation of the executive. Even though our sister dominion, which parted from us in 1947, saw intermittent impositions of martial law repeatedly, our constitution has been protecting the democratic polity of our country for the past about 7.5 decades. The judicially evolved basic structure doctrine also turned out to be an effective tool against executive adventurism to tamper with the tenets of the constitutional principles envisaged by our founding fathers. At this juncture, I also wanted to point out that our chief guest is the son of Justice K.K. Matthew, who was part of that historic verdict in Keshavananda Bharati case. Justice K.K. Matthew was part of that historic verdict. However, there has occurred a recent phenomenon whereby imputations are made on our constitution, attributing to it colonial hangover and being contrary to the purported Bharatiya ethos. Even high-ranked constitutional dignitaries have openly criticized basic doctrine structure as something contrary to and being a hindrance on parliamentary supremacy. One cannot be found fault for doubting that the decks are being cleared for an apparent revisiting of the provisions of our constitution, if not its total overhaul. As I said earlier, our country is a sovereign, socialist, secular, democratic republic only because of our constitution. The citizens of this country have to be guarded against any such remotest possibility of tampering with our constitution. I am certainly hopeful of the power of Indian democracy and the ability of the Indian populace to stand together to protect the country and our constitution in such testing times, which we all witnessed in the electoral dawn that crumbled the dark days of emergency. Nearly all that is amazing has been completed by the fledgling youth. Campuses have been the harbingers of change. I am concluding my address calling upon my young friends to swear to yourself that each one of you will rise to the occasion and be the vanguards of the Constitution. Let me wish the conference a grand success. Thank you. Thank you very much.
Thank you for your kind words, sir. Now I request Dr. Mini Paul, our faculty, to present Advocate Manoj Kumar with the momento. Dr. Premsi PN, faculty of the Government Law College, Ernakulam, will now deliver the felicitation.
Honorable Justice K.M. Joseph, sir, respected Advocate Manoj Kumar, N, State Attorney, our principal, Dr. Bindom Nambia, Dr. Girijan, Advocate Girijan, sir, Isa, Sanjana, Mini Paul teacher, other respected faculties, participants, and my dear students. It is actually with immense pleasure and deep sense of honor that I stand before you today to deliver this felicitation address at this National Conference on Constitution Changing India. This event, entirely organized by the Students' Union, marks a significant milestone in our ongoing dialogue about the evolving nature of our nation's foundational document. We know that we are going out of time, actually, and so that I'm not talking much about the intricacies of India's present position as well as the significance of constitution in the changing situation in India also. Anyway, I would like to congratulate the entire team behind this, this conference under the leadership of Sangeet as well as Chairman Isa and Vice Chairperson Sanjana and all the other students behind this program. And I wish that this program be a grand success, and I conclude by this. Thank you one and all.
Thank you, ma'am. Next, I call upon Advocate P.T. Girijan, Vice President of the Law College's PTA, to felicitate the session.
Respected Chief Guest of the Day, Honorable Mr. Justice K.M. Joseph, former Judge, Supreme Court of India. Respected State Attorney, Government of Kerala, and my friend, Advocate N. Manoj Kumar. Dynamic College Union Chairman Isa Farhan, College Vice Chairperson Sanjana S. Kumar, PTA Secretary Dr. Mini Paul, Girishankar sir, respected the other teachers, my dear friends. We have just listened to the informative and thought-provoking lectures of Minister P. Rajeev, eminent Judge Mr. Justice K.M. Joseph, State Attorney Manoj Kumar. I am sure that it was a wonderful experience to all of us. I wish to record our sincere appreciation to these persons on behalf of you. It is a pleasure and privilege to be here today to address this distinguished gathering of constitutional experts, legal luminaries, and other participants in this national seminar on the Constitution in a changing India. This day marks a special occasion in the history of Government Law College Ernakulam. On behalf of the PTA committee, I extend my best wishes to all the participants and all those associated with this seminar. I congratulate the organizers for appropriately arranging this seminar as part of the 150th years of celebrations of our college. The subject of today's seminar is quite vast. I noticed that some specific issues have been listed in the program of the seminar. I am sure that the participants who are drawn from various law colleges across the country would go deep into the issues involved and make meaningful suggestions for strengthening the democratic and constitutional process in the country. I am also grateful to the organizers to the function for giving me this opportunity to share my thoughts with you. In conclusion, I am wishing each and every one of you a successful and fruitful future. I wish the seminar all success. Thank you all.
Thank you for your kind words, sir. Finally, we have Dr. Mini Paul, Union in Charge and Staff Coordinator, to deliver the felicitation.
Respected dignitaries on the dais, Principal, Dr. Bindu and Damyar, Sri P. Rajeev, Minister of Industries, Law and Coir, Government of Kerala. Chief Guest of the Day, Justice K.M. Joseph, former Judge, Supreme Court of India. Advocate Manoj Kumar, BCI Executive Vice Chairman. Dr. Girishankar SS, Principal, St. Dominic's College, Kanjirapalli. Isa Fohan, College Union Chairman. Sanjana, faculty members, students, and all other participants of this function. Now, I'm indeed privileged and honored to offer my felicitations to this August gathering, the National Conference on the topic, Constitution in a Changing India. I'm indeed proud of my students who have organized this 3-day conference, the first of its kind in the state. I would say so because it is entirely 100% a student's initiative. The difficulties and hazards in organizing a function of this nature is indeed known to all. The college union, headed by Isa Fahan, has worked relentlessly day and night to make this conference happen. The fact that the students from colleges nationwide have participated in this program is itself evident of the grand success of this program. I sincerely congratulate the organizers of this program the very best. May this even be a torchbearer to the students of this college and other colleges of the state to organize events of such nature in the future. My heartiest congratulations and best wishes to this program. Thank you.
We've almost reached the end of the inaugural session. Now Sanjana, our Vice Chairperson, will deliver the vote of thanks.
Respected dignitaries on the dais, teachers and my dear friends, I'm deeply honored and privileged to address you all at this National Conference 2024 on the Constitution in a Changing India. So since we have sessions coming up, I'm not taking much of time. At the very outset, I would like to thank the Chief Guest of the Day, former Judge, Supreme Court of India, Justice K.M. Joseph, sir, for giving us valuable insights on the various aspects of the Constitution. Thank you, sir. Next, I would like to thank Minister of Industries, Law and Coir, Kerala Government, Sri P. Rajeev, for inaugurating the session amidst his busy schedule, thanking him in his absence. Next, I would like to thank State Attorney, Kerala Government, Advocate Manoj Kumar M. sir, for presenting the keynote address and being a part of the program with us. Thank you, sir. I would also like to thank Dr. Bindu M. Nambiar, Principal, Government Law College, Ernakulam, along with our dear teachers, Mini Pol ma'am, Staff Advisor, Union in Charge, and Prem C. ma'am, Faculty, Government Law College, Ernakulam, for delivering the felicitations. Thank you, teachers. Next, I would like to thank PTA Vice President, Advocate P.T. Girijan, sir, for his presence to the function. Thank you, sir. And from the beginning of the program, it has been said it's a student-driven initiative. And Indu has already said in the beginning, for a college celebrating 150th year of its establishment, it's for the first time that a student-driven national conference has been conducted. But this student-driven part of this program has been very hard because we are students. Of course, our resources are very limited, be it money or the contacts or connections. But this program would never been possible without these three people. First, I would like to thank our former professor, Dr. Girishankar SS, because we have been contacting him for the past 3 months for each and every scratch of the program, be it the topic, be it the speakers, or many other things, even the small aspects of this program. So thank you very much, sir. Next, I would also like to thank, in the absence of the senior senior advocate, Mr. Dinesh, Advocate Dinesh, who is the co-founder of LiveLaw. I would like to thank him also in this program. And also I would like to thank Manoj Kumar sir for his help throughout the program. And last but not the least, I would like to thank the sponsors of the program, of course our live streaming partner, the LiveLaw, and all the other sponsors of the program. And last but not the least, I would like to thank the volunteers of the program for their support, and of course all the participants who have assembled here to the program amidst this ill weather. Thanking all of you. Thank you very much.
Thank you, Sanjana. We have now reached the end of the inaugural session. We'll take a short break for lunch now, and we'll regroup here for the plenary session.